The first 13 candidates were interviewed yesterday. Yesterday, I also announced that 14 candidates would be interviewed today. Regrettably, 2 candidates who were scheduled to be interviewed today have withdrawn their candidature due to personal reasons. Accordingly, 12 candidates will now be interviewed. The procedure to be followed in today's interviews will be similar to the procedure that the Judicial Service Commission followed yesterday in conducting interviews for candidates who were scheduled to be interviewed on the first day. As indicated, the proceedings are being streamed live on ZBC, ZTN, and the Judicial Service Commission's Facebook page and X handle. From the 27 candidates who qualified for public interviews, today the last 12 candidates will be interviewed, as I have already said. Let me take this opportunity to welcome the candidates scheduled for today's session. Each interview is expected at least to last no more than 30 minutes. The procedure that will be followed is as follows. 1, I will ask 3 standard questions of each candidate. 2, I will then open the interview up to my fellow commissioners who may also ask questions. And 3, thereafter, the candidate will be excused. At the end of each session, each commissioner will independently score each candidate under specified heads. After all the candidates have been interviewed, the commissioners will retire and deliberate on the respective performances. A list of qualifying candidates will then be prepared and submitted to His Excellency the President in terms of the Constitution. As was done yesterday, what will now happen is that the candidates will be quarantined in one room. They will not be accessible to the public until they are interviewed. After being interviewed, if a candidate wishes to remain in attendance, he or she is allowed to do so. I wish each candidate good luck. All the candidates are now excused and will be escorted back to the quarantine room, except for Mr. Joseph Masango, who is the first candidate to be interviewed this morning. I appeal to all those in attendance to exercise silence throughout the proceedings to enable the commissioners to do their work of carrying out the interviews without interference. I thank you. Yes, thank you. Mr. Masango, we welcome you to this interview. As I have already indicated, I will ask you 3 questions. The first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Chief Justice. What distinguishes the two is that a dispute of interest is for any dispute other than a dispute of right. And a dispute of right is one whereby the basis of the claim is a case of non-fair labor practice, as defined in Section 8 of the Labor Act, or a violation of certain provisions of the Labor Act, or violation of the collective bargaining agreement, or a violation of the conduct of employment. Any dispute regarding that, then that is a dispute of right. Anything else is a dispute of interest. In other words, it's not based on rights and obligations. That is a distinction. Chief Justice, may I have the second question, please? May you please repeat the second question?
How does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Chief Justice. If it is a dispute of right, then typically the labor officer or DA, the designated agent, may refer that dispute to compulsory arbitration. If it is a dispute of right, that person may. But if it is a dispute of interest, if it is in an essential service area, then in that case, that dispute of interest may be referred to an independent arbitrator. Thank you.
Yes. The second question is as follows. What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
The first step is that the judge, Meremotu, may observe whether or not it is a constitutional matter. In that case, he has to refer it to the Constitutional Court. After that, he may ask the parties to make submissions regarding the question, the constitutional question to be answered. Then he himself must also state what he sees as a constitutional question to be addressed to the Constitutional Court.
Yes. The third and last question is as follows. What is the appropriate test for determining whether the labor court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellant interference in labor appeals?
May I repeat that, Chief Justice?
Yes, you may switch off your mic. What is the appropriate test for determining whether the Labor Court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court's interference in labor appeals.
Thank you, Chief Justice. The test is at a point of law. That's the test, a point. It must be, in that case, the test is that it must be a point of law for it to then be taken on appeal.
Thank you. I'll now hand you over to the other commissioners for further questions if they have any questions. Yes, DCJ.
Thank you, Honorable CJ. Good morning, Mr. Masango.
Good morning, Commissioner.
I have one question for you, and it goes as follows. Given the scope of the matters that appear before the Labor Court, can you list the possible agents that may represent parties before the court, as highlighted by the Labor Act, Chapter 2801?
My apologies, Commissioner, can you repeat it?
Sure. Given the scope of the matters that appear before the Labor Court, can you list possible agents that may represent parties before the court, as highlighted by the Labor Act?
One is in the event of, for example, in a strike situation where there's the minister may want to issue a show cause order, in which case there should be a disposal order by the Labor Court. In that manner, can be treated as an urgent matter. That's one example.
The question does not relate to urgent matters. The word I used was agents, is A-G-E-N-T-S.
Okay.
Agents who may represent.
Agents who may not represent.
Who may represent parties before the court.
Okay, I understand. Number one, a legal practitioner. Number two, in the case of an employee, a union official or a union employee, if he produces proof that he has been authorized to represent. If it is a company, then a common official, such as, for example, a common secretary or director or HR practitioner.
Yes, thank you. Thank you, CJ.
Yes, Commissioner.
Thank you, Honorable Chief Justice. Good morning, Mr. Masango.
Good morning, Commissioner.
Yes, Mr. Masango, looking at your personal profile, it's very impressive. And this is very, very commendable. In fact, I noticed even your first stage interviews, you demonstrated a very good understanding of both substantive and procedural legal concepts. However, Mr. Masango, I'm very curious to understand your motivation. I appreciate your sincerity, but I just wanted to know what inspired you to apply for this position at this stage of your career.
Thank you, Commissioner. What motivated me was to hopefully influence the law in Zimbabwe. It would be easier, in my view, to influence it by virtue of being a judge. And in that position, my decisions will serve as precedents to lower bodies, lower tribunals, labor officers. So that's one of the reasons why I was motivated, that influence. The second reason is I've been very long in the private sector as well as a legal practitioner. At that other level, there is a different skill set required of me. So in the interest of exercising that skill set, I thought it's best that I practice it in my capacity as a labor court judge. Thank you.
Thank you very much indeed. It's never too late to try any new area. Thank you, Chief Justice.
Thank you, Chief Justice. Dr. Masango, I have one question for you. And here is the question. What are the potential legal consequences for an employee who resigns without proper notice? And how should the Labor Code interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
I have to ask you again to repeat the question. My apologies.
I will do that. Here it goes. What are the potential legal consequences for an employee who resigns without giving proper notice? And how should the Labor Code interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
Thank you, Commissioner. A resignation is a unilateral act. So if a person chooses to resign without notice, yes, it is right. The consequence, however, is that typically, in that case, the employer is entitled to deduct the equivalent in notice period. So that's the consequence of resigning without giving notice. And as far as the Labor Court is concerned, in that case, really there's not much, if I understand your question, that the Labor Court can do in that case because he has chosen to leave. And really there's not much that the Labor Court can do, if I understand your question, Commissioner.
Thank you. And just by way of follow-up, at this stage, would you be able to direct us to any provision in the Act that's in the Labor Act that may express the views that you do express, or at this stage you're not in a position to provide us with that particular section of the legislation?
Commissioner, not at the moment in terms of the specific section.
Thank you very much, Doctor, and thank you, Sitja.
Thank you, Honorable Chief Justice. And good morning, Dr. Masango.
Good morning, Commissioner.
I will probably have just one question for you. And it goes, how should the phrase redress any dispute in Section 63, subsection 3A of the Labor Act be construed? Does it permit a designated agent to entertain appeals on the merits of a determination or only to initiate conciliation?
Again, if you may repeat the question, my apologies.
How should the phrase redress any dispute in Section 63, subsection 3A of the Labor Act be construed? Does it permit a designated agent to entertain appeals on the merits of a determination or only initiate conciliation?
Thank you, Commissioner. That entitles the designated agent to initiate. In fact, if it's to redress, it's a choice which means between attempt to redress and to redress. In that case, he has to determine the matter. There's no conciliation involved. If he redresses, he must come up with a decision to distinguish from attempt to redress.
Are you done?
I'm done, thank you.
Thank you, Honorable Chief Justice.
Yes, thank you.
Yes, good morning, Mr. Masango. I have one question for you. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe, 2013?
The mechanism is that, first of all, that manifests itself as an unfair labor practice. So in terms of the Act, unfair labor practice must be reported to the labor officer. Then upon this, or the designated agent, depending on where the person falls, then the person must then conciliate the parties, and if agreed, they issue a certificate of settlement. If there's no agreement, then a certificate of no settlement. Then the next stage follows. For example, referred to in a compulsory arbitration. Thank you.
Just spoken of the Act, are there any other provisions in Zimbabwean law that address the issue, the question that I've posed to you?
None at the present moment, Commissioner.
Thank you.
Thank you very much, Chief Justice. Dr. Masango, good morning.
Good morning, Commissioner.
I will pose a two-part question. Under the Labor Act, what is the collective bargaining agreement? And the second part is, what are the prerequisites for its validity?
Thank you, Commissioner. A collective bargaining agreement is that agreement which is concluded between two parties in the labor relations system, being the employer on the one hand and even a workers' committee on the other hand, or an employer and a registered trade union, or an employer and an employer organization. Those are the parties that can conclude a collective bargaining agreement for purposes of regulating the conditions, the terms and conditions of employment of the employees in that sector or industry. Regarding the second question, prerequisites for its validity. Upon its conclusion, it must be submitted to the registrar for registration. Then, once it's registered, it must be publicized. After publication, then it has to be made available at certain places. At that juncture, then it becomes enforceable. Thank you.
Is there any room for participation of members or representatives of members in the process that you've just outlined, in order for the collective bargaining agreement to be valid?
Members meaning what? Because upon conclusion, it must be submitted to the registrar. Yes, there could be room of challenging it, but generally it must be submitted to the registrar for registration. And in the process, it be pointed out that if anyone wishes to object, then they can object. That's my understanding.
Thank you.
Thank you.
Thank you, Honorable Chief Justice. Good morning, Dr. Masango.
Good morning, Commissioner.
I have one question. How does Section 90A of the Labor Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
If the Commissioner may repeat the question again, my apologies.
Okay. How does Section 90A of the Labor Act relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
Thank you, Commissioner. It relaxes these by allowing the bodies that involved in hearing evidence to be more on the informal side and accept evidence in their minds as to ensure that it advances the interests or the intention of Section 2 of the Labor Act. So that must be the guide in terms of relaxing the evidence. In other words, they don't approach it like a typical court. They relax, they have to ensure that it's so more on the informal side, such that they don't miss ensuring that at the end of it all, the intention of Section 2 of the Labor Act has been achieved. Then the second question, please, if you may remember. Oh, thank you.
Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Good morning, Dr. Masango.
Good morning, Commissioner.
You've been running a law firm since 2016?
I didn't hear that.
You've been running a law firm since the year 2016?
Yes, Commissioner.
What are the challenges you found in running a law firm?
One of the challenges which I found in running a law firm is, for example, in the area where I am, which is Kwekwe, for a small town, there are too many legal practitioners. As a result, we may have to compete, but in a way that is ethical and meets the standards set by the Law Society. So the challenge is that business may be low, and as a result, there's always a danger that there may be certain unethical standards by other competitors, resulting in a reduced volume of business. That's one challenge I've encountered. The other challenge is that clients, being what they are, they have certain expectations. For example, if you are honest and tell them that, look, in this case, you cannot represent them, then that reputation says they think that you don't know. Yet, in your view, it's improper. You don't believe that they have a case. It's like they prefer that the moment they take a matter to a legal practitioner, he must perform magic, however it is, so that it brings results. Number two, they don't believe that a legal practitioner should lose a case. To them, once the matter is in the hands of a legal practitioner, there must be success at the end of it all. So those are the challenges I can say I've met in the course of legal practice. Thank you.
I specifically wanted challenges relating to the running of a law firm rather than just practicing law, because I think those are common to everyone. Have you found, for example, that practicing in Kwekwe limits your access to the superior courts?
No, Commissioner, because of ICAMS, it's now more accessible, because the principles surrounding ICAMS are such that even someone in my area, I do not have problems in accessing. My clients also don't have problems in accessing justice. Thank you.
Thank you, Chief Justice.
Thank you, Chief Justice. Good morning, Dr. Masango.
Morning, Commissioner.
Yes, I have one question for you. Does the Labour Court have unlimited jurisdiction over all labor matters?
Thank you, Commissioner. Only in the first instance. So in other words, while it has exclusive jurisdiction, but the qualification that only in the first instance. Thank you.
Maybe you may need to relook at that again. My question is, does it have jurisdiction over all labor matters, over all?
Over all labor matters? I would say yes, in terms of the Constitution, 172, yes, it has jurisdiction over all labor matters, but specifically those provided for in the Employment Act.
Thank you, Chief Justice.
Thank you.
Are you computer literate?
Yes, Chief Justice.
You are,
Yes, Chief Justice.
but you got 0 in the examination that was testing your proficiency in the use of computers in the judiciary.
Yes, Chief Justice. The simple reason is that I have not, of late, since inception of ICAMS, I have not had a matter that required me to use ICAMS. That is the only reason. But otherwise, in terms of computer literacy, I am.
It would mean you have not been practicing at all for the past. ECMS was introduced in the courts in 2022. So all lawyers would by now know how to use ECMS in the courts. You mean you have not been, you have not had any case where you needed to represent your clients electronically? You have not done that, you don't know?
Most of my cases since that time have been at the magistrate court, arbitration before DAs and labor officers. Also, most of my issues have been resolved through negotiation. As a result, there has been no need to go to ICAMS to take matters to the High Court or the Supreme Court or to the Labor Court.
So you really have not been practicing in the higher courts?
I have not had a matter, yes, I have not had a matter in the higher courts since that time, but in
now,
lower courts.
Yes, I understand what that may not be your fault, but that is where the difficulty is, that knowledge of how to navigate the IECMS is a critical factor in now in consideration of appointment to the judiciary. How do you fare when you have no knowledge at all about this system? Because all judges now, everybody in the courts must have this knowledge, and lawyers must have the knowledge. So if you intend to come to the courts with a 0 knowledge on computer use, you are far behind. And how do we deal with a person like that in the courts as a judge?
Thank you, Chief Justice. Since then, the JSC has been kind enough to offer training, and I've already done the training. So I would say, as at now, I am now literate in that regard in terms of using ICAMS, because I participate in the training.
You got to 0 about 2 weeks. When was it, last month?
And after that, they did run workshops on ICAMS, and I participated in the workshops.
Where did you participate? Can you give me examples of where you participated and who was carrying out the training?
ICAMS offered training in preparation of extending it to magistrates, so it was virtual. So I participated. I'm sure a JSC can confirm that they offered such training, but it was after that examination. Yes.
It's the only participation the only opportunity you took advantage of?
Right now, also, because I've undergone that training, right now I have matters which are going to the High Court, several, about 3 matters, and I am now using ICAMS to progress those matters. So I'm now confident that I can do it.
I would like to ask you one more question.
Yes, Dr. Masango. I know that in the questionnaire that you filled in, the question number 3.1, which relates to the interaction you have had or appearance you have made in various courts. The question doesn't actually ask you to give the names of the, or to cite the cases, giving the parties' names. And you have, in an addendum, you were just referring to a date and then giving the details of the case without indicating what the names of the parties. Would you be able to provide that information?
Yes, Commissioner, in terms of the names of the parties, I'll be able to. If they're not too far in the past, yes, I'm able to.
Thank you.
Doesn't that show a bit of laxity of attitude to detail? Why would you leave with such important details when you need to communicate yourself, your ability, your level of competence to a body like this? Why would you leave such very important detail? Doesn't it show a bit of free type of person, just you don't care? Is that a correct assessment?
Thank you, Chief Justice. If I may respond, let me start by saying that there was a point that if you need clarification or anything, because having read that instruction, it seemed to be confining to the date and the matter itself. It did not require you to cite. Indeed, I followed up with JC to ask, should I not cite the matter? And there was no response. Regarding that, I therefore did not. Otherwise, I would have cited. But I can understand where the Chief Justice is coming from. But I did seek that clarification because I definitely wanted to cite. But absent an answer, then I thought maybe it was not required. Otherwise, I would have cited. And JC can testify that indeed I asked them.
And you got no response?
I got no response, yes. They can also confirm that they did not respond to that specific inquiry.
But still, as the Honorable CJ has said, surely you could have said to yourself, if I just give a date and the facts, will they be able to identify the case? You could have asked yourself that question. Because what we have, like I'm looking at what you wrote here, High Court, date 27/05/15. I made a re-vindication application and so forth and so, and you give all these details. How can anyone, after reading this, how can anyone identify the case in question? Because on that particular date, I'm sure there were many cases that the court had.
I hear the concerns of the CJ and Commissioner. Yes, I should have done that. But for the reasons I've given, I didn't, and I apologize for that. And I actually thought that maybe when I come here, I may actually be asked that in this case, who were the parties? But otherwise, I totally understand where the Chief Justice is coming from. I should have taken that one and cited the case.
the reason why these questions are coming is because attitude is a very important attribute of a good judicial officer. The ability to self-motivate is critical for a successful professional approach to the performance of the judicial function. That is where efficiency comes in, expeditious disposition of cases come in because of these characteristics of the person. Now, if you are a person who's very laxy, the tendency is that you fall into that group that is giving. You may fall into a group that is giving the Judicial Service Commission problems on performance, lackadaisical, carefree, needing supervision all the time. Doesn't this kind of behavior show that? Even in the attitude to ECMS is worrying. We cannot understand how, as a lawyer, senior lawyer, you can still be in a position of not knowing, unless you didn't care. You didn't care about the transition, the changes that are taking place in the legal profession. You didn't care. Is that correct? Why should we have that underlying characteristic of yourself? I don't know whether we summarize you properly. We need an advantage of clarification from yourself.
Thank you, Chief Justice. Yes, I totally understand, and I should have done, definitely I should have done that. However, it certainly does not define me or my attitude or my approach to work, certainly not. And should I be appointed, I can assure that I would never ever do that. In other words, that lax attitude to work, needing supervision, definitely I will not put the judiciary in that situation at all. But what happened, I totally understand. It should not have happened.
Able to refer us backwards to your professional work, to matters that could justify what you are saying?
Yes, Chief Justice. Going back in history, my CV shows that I was not stagnant. In each company I worked for, there were a series of promotions. That shows that my supervisors were most happy with my work. Even outside the country, being an expatriate, you not expect one to develop, to be promoted to other positions. But I was, because they were happy with my work, not in terms of just technical ability, but attitude towards work. Overall, particularly for an expatriate, 12 years outside in one company, they would have certainly not renewed my contract. So it shows, to answer, it shows that they were happy and content with my work, including attitude towards work. Not only that, I would believe that if there was lax in my attitude, certainly a client would have reported me to the law society for not having progressed a matter. And nothing like that happened. Again, that testifies to my character, that I'm not the type of person who would want to be supervised. I'm a go-getter. And in the process, I follow ethical standards. But particularly, I would not need to be supervised, and I don't take a lackadaisical approach to my work. Thank you, Chief Justice.
Yes, thank you. We have come to the end of your interview. You are excused.
Thank you, Commissioner. Thank you, Chief.
Yes, confirm we have Mawire Tungamirai.
Good morning, Chief
That's
Justice.
fine,
I
thank
confirm.
you. As I indicated, I will be asking you 3 questions. The first question is as follows. What distinguishes a dispute of interest from a dispute of right under Section 93 of the Labor Act? And how does that classification determine whether arbitration is voluntary or compulsory?
Thank you, Chief Justice. The distinction between a dispute of right and a dispute of interest is canvassed in Section 2 of the Labor Relations Act, Chapter 2801, which provides for interpretation of terms used in the Act. In terms of definitions, dispute of interest is defined as any dispute which is not a dispute of right. And that definition is not helpful because it borrows from the definition of dispute of right. So one has to understand the dispute of right first before appreciating what a dispute of interest is. And a dispute of right is any dispute concerning rights or obligations which are provided for in the Act, which include disputes arising mainly from sources of labor rights. That is an actual or alleged unfair labor practice or a breach of the main Act or regulations made under the Act, or a breach or alleged breach of a collective bargaining agreement, or a breach of the contract of employment, which may be defined broadly to include rights that may emanate even from decided cases. So the definitions are then used in the dispute resolution discourse provided in Section 93, in that when a labor officer or designated agent conciliates a dispute after a certificate of no settlement is issued where there hasn't been any agreement, you then decide which route to take depending on whether the dispute is a dispute of interest or a dispute of right. Now, a dispute of interest is not clear in terms of definition, but through decided cases, through common law, through ordinary interpretation, these have been referred to as negotiation disputes or economic disputes by some authors. And these relate to negotiation of a new term or condition of employment or a review of an existing term. So if it is a dispute of interest, you have to ask yourself if it is a dispute in the essential service or non-essential service. If it is a dispute of interest in an essential service, then you have to refer to a compulsory arbitrator, because those disputes have to be resolved urgently, and also because employees in the essential service are not allowed to go on strike. Then if it is a dispute of interest in a non-essential service, such employees cannot be forced to go to compulsory arbitration unless they agree to go to voluntary arbitration. Then if it is a dispute of right, by national jurisprudence and international labor jurisprudence, disputes of rights must be referred to an independent adjudicator who resolves those issues, because they are disputes of rights, disputes of entitlement. They are easy to identify, and what is left is just for enforcement. So they must appear before an independent someone. So they go to compulsory arbitration. That's the significance of the distinction as they are then implemented those rights in terms of Section 93, Chief Justice.
Yes, the second question, you may switch off the... The second question is as follows. What steps must a labor court judge take to properly address and decide a constitutional question arising during its proceedings, if any?
Thank you, Chief Justice. If a labor court judge is seized with a constitutional matter, he or she is guided by Section 175(4) of the Constitution, which stipulates that if a constitutional matter arises in any proceedings before a court, that's other than the Constitutional Court, the presiding judge may, and if so requested by a party to the proceedings, shall refer the matter to the Constitutional Court. So in this instance, it will be the labor court judge determining whether or not a constitutional matter arises, guided by the definition of constitutional matter in Section 322, I think, of the Constitution, where it's defined as any matter concerning the interpretation, enforcement, or protection of the Constitution. So once the judge, on his own initiative, Meromoto decides that there is a constitutional matter for reference, he may then consult with the parties and refer the matter in terms of the Constitutional Court rules to the Constitutional Court. There is also the second rung, where upon request by a party to the proceedings, the presiding judge has to follow due process to determine whether or not there is a constitutional matter, and also whether or not the request itself is not frivolous or vexatious. And once he decides that the request is not frivolous or vexatious, then he has an obligation to refer to the Constitutional Court following the referral procedure after hearing the parties, confirming the facts, making sure that all factual issues are resolved either through a statement of agreed facts or carrying out a hearing within a hearing on facts, and then identifying the issues for reference to the Constitutional Court, Chief Justice.
And last question is as follows. What is the appropriate test for determining whether the labor court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals?
Thank you very much, Chief Justice. I think the labor court, which is seized with an appeal, will have to check on the reasonableness of the decision by the tribunal or court, particularly whether or not the decision is so grossly unreasonable with respect to how the tribunal came up with the decision, and whether there are any errors with respect to appreciation of the facts, as an example, or whether or not the tribunal considered any extraneous factors which were unnecessary in the circumstances, or there is a misapprehension of facts, misunderstanding of facts or misapplication of facts, or a gross error in law, such that the decision that comes out of the interrogation of those factors by the court quo is so grossly unreasonable to the extent that no court exercising its mind to the decision would have come up with such a decision. It induces a shock, a sense of shock to any reasonable adjudicator in the circumstances. It defies logic. I would give an example of a collective bargaining dispute where the parties provided the adjudicator.
Sorry, perhaps I should stop you there. Have you understood the question? You seem to be talking about the relationship between the labor court and disciplinary bodies at employment level. That's not the question. Have you understood the question? Because there's critical legal implications of the question. Have you understood the courts that are being involved? We have said the labor court decision, not a disciplinary committee decision.
Perhaps I can have the question once more, Chief Justice.
Sorry?
Perhaps I can have the question once more?
You want the question repeated?
Yes.
The question reads as follows. What is the appropriate test for determining whether the labor court's factual findings are, quote, so grossly irrational, unquote, as to warrant appellate court interference in labor appeals?
Thank you very much, Chief Justice. The overriding principle is that an appeal from the labor court to the Supreme Court is on points of law, not points of fact. So the test that is going to be used by the Superior Court is whether or not the labor court misdirected itself grossly on facts to the extent that the misdirection then becomes a point of law.
Thank you. I will now hand you over to the other commissioners for further questions if they have them.
Thank you, Chief Justice.
Yes, thank you, CJ. Mr. Mawire, good morning. I have one question for you, and I'll read it slowly. Given the scope of the matters that appear before the labor court, can you list the possible agents that may represent parties before the court as highlighted by the Labor Act, Chapter 2801?
Thank you very much, Deputy Chief Justice. In terms of the Labor Act, the legislature recognized that parties to the dispute are primarily the employer and the employee. But in terms of the democratic regulation of labor relations in Zimbabwe, parties are entitled to representation collectively. So on the part of employees and employers, the agents that may represent them respectively, for unions, members from that union, provided the employee in question, the litigant, is a member of the union. The same applies to employers. Employers can form employers' organizations to represent their interests, and the representative who can appear before the labor court is a member of the employer's organization. That is the company that is a member of the employer's organization, a person coming from that company, as long as that company is a member of the employer's organization. The same applies to federations. Then, when it comes to legal practitioners, yes, the legal practitioners also have the right to appear before the labor court, as long as they are registered in terms of the Legal Practitioners Act. Then finally, there is also an extension to companies where those that have the mandate to represent the companies can then have audience at the labor court, and these would be the managing directors, like the company lawyers, the company secretaries, or those from human resources department. Now they call them human capital practitioners in some circles, but those would be the persons responsible for administration of human resources. Thank you, Deputy Chief Justice.
Yes, thank you for your answers.
Thank you, Honorable Chief Justice, and good morning, Mr. Mawire. Now, Mr. Mawire, given your employment history, including your affiliation to various labor organizations, I noticed from your profile, you have been legal advisor to the Employers Confederation of Zimbabwe. You have been also legal advisor to the Zimbabwe Congress of Trade Unions. You have been an advisory member of the National Tripartite Negotiating Forum, just to name a few. Now my question is, how are you going to maintain impartiality and also avoid conflict of interest in the event that you become a judge of the labor court?
Thank you very much, Commissioner. Yes, you are very correct in that my working life has revolved around labor market players, and I've also been a legal advisor in the Ministry of Public Service, Labor and Social Welfare. In fact, that has made my life very easy, Commissioner, in terms of labor jurisprudence, in practicing, in drafting of labor market policies, in training, in ILO standards. I have interacted with a lot of players in the labor field, and that will not affect my work at all, because assuming I'm appointed to the bench, all relations with those players will cease, and if there are any persons I have been involved with and they appear before me where there is conflict of interest, I'll stand guided by the judge's ethics, where I'll then, in very exceptional circumstances, recuse myself. But the fact that I have interacted with these players has enriched my competence, particularly in the field of adjudication. Thank you, Commissioner.
Thank you, Chief Justice. I'm answered.
Important question. We need to be clear before we move on with you. You have footprints almost everywhere in the labor relations fields or sectors. Now, for a judge to perform judicial functions, there should be very few cases of self-recusal. How are you, with a sea of activity around you, you'll almost recuse yourself on a daily basis? That is the question, a critical question indeed. How do you explain it to us, that kind of problem? What solution do you have?
Thank you very much, Chief Justice. I think I can allay your apprehension by indicating that even just before I came here, I've been concluding matters that I've been handling as an arbitrator. And I've been arbitrating in cases where I have worked with a lot of colleagues and they have accepted my independence. I've arbitrated where fellow advocates have appeared before me. Tomorrow we are on different perhaps levels, representing our different litigants. I've always maintained my impartiality, regardless of the fact that I've been swimming in a pool of labor practitioners the whole of my working life. So yes, consciously, I will be able to distinguish between what I have been and what I will be when I joined the bench. The only matters that I would recuse myself from, obviously, would be those that I would have handled at the law firm, and then someone appears before me when the matter started, when I had not joined the bench. But otherwise, the fact that I trained someone on international labor standards, I have been training ministry arbitrators, I've been training NEC arbitrators, I've been chairing NEC's tribunals. If I got that fear, I would not arbitrate at all, and I would not be a judge of this country, because I have interacted with a lot of them, but I will be able to be independent. Thank you, Chief Justice.
Have you been faced with this case that is under consideration in the arbitration of these cases where parties have asked you to recuse yourself because of your involvement in the case, in organizations that have interest in the litigation? Have you faced that kind of situation?
I can confirm to the Commission that I've handled arbitration cases since 1994 to date. I have never been asked to recuse myself in any matter. Thank you.
If you were to be, because there will be these cases, if you were to be asked to recuse yourself, what principles would you apply in dealing with such a case?
Thank you very much, Chief Justice. I think, guided by precedent, whenever a judicial officer is requested to recuse themselves, they are guided by the two-pronged test of reasonability, that I must be reasonable in interrogating the request at hand. Is there a material factor that might cloud my judgment? Will be the overriding question. And also, is the request itself, is the apprehension itself reasonable? So it is only in circumstances where justice must be seen to be done and there is a very strong factor that might affect my impartiality. And it is only in those circumstances that I may recuse myself. Otherwise, a decision should be made, because in compulsory arbitration primarily, there is that tendency of litigants to want to choose arbitrators. And it happens a lot in NECs where they are designated agents. It also happens a lot at the Ministry of Labor, where someone may say, I do not want to appear before you because you once made a decision against this grouping, or you once pronounced yourself. And it is also a question of competence, because sometimes lawyers will be knowing which are the competent arbitrators in the NECs or in the ministry. So it is very important that once I'm seized with such a matter, I will have to stand my ground where I realize that the request is frivolous. Chief Justice.
Thank you, Chief Justice, and good morning. Now, I have one question for you. What are the potential legal consequences for an employee who resigns without giving proper notice, and how should the Labor Court interpret such a resignation under Zimbabwe's labor legislation and principles of fairness?
Commissioner, for that question. Yes, termination on notice has been quite a contentious issue in this country. But just in short, termination on notice is provided for in Section 12(4) of the Labour Act, which provides for the thresholds that are utilized by an employer or an employee who wants to terminate. And termination notice must be complementary to a ground for termination, which means if you are terminating on grounds of retrenchment, the ground for termination is retrenchment, but you must then give notice. If you are terminating on mutual agreement is the ground, but you then give the relevant notice. There are very few instances where notice may not be given, like where an employee dies. That could be an example. What has been the problem is whether or not notice on its own can be used as a no-fault termination ground. And it is clear that from precedents, the Constitutional Court, Zua judgment has held that, yes, it still stands a ground. So where an employee resigns without giving notice, where in fact you must give notice in terms of Section 12(4), then there are legal consequences to follow. The legal consequences would be, I'm presuming here that you were supposed to give notice, because if you were not supposed to give notice by agreement, then there are no consequences as such. But if you were supposed to give notice, then number one is a resignation is a final act. It terminates the contract of employment. We have been having that through common law, through precedent, but now it's covered under Section 12(4)(a) of the Labour Act as amended by 11 of 2023, which provides that termination by an employee or at the initiative of an employee may be through resignation or retirement. So resignation is now a final act terminating the contract of employment by the employee in terms of legislation and in terms of common law. And once an employee does that without giving notice, then the employee, unless the employer waives the right to be given that notice, the employee may be penalized, cash in lieu of the offensive conduct of not giving notice. And I've also said, I'm assuming that the employee, sorry, I must also add that I'm assuming that the employee in fact effectively resigned, because there are also issues around resignation. Like an intention to resign is not resignation. So there will be jurisprudential issues around the resignation itself. And once the employee resigns and the employer is received the resignation, the employee cannot then retract his resignation without the consent of the employee if the employer says you must pay. So those are some of the legal consequences, and our courts have dealt with that in cases like Lee versus Lee Group of Companies versus Mary Muzengi versus Standard Chartered Bank, just to mention a few around resignation. So the main consequence, yes, is that the employee will have to make up for the offense, unless in terms of Section 12B(4) of the Act, it is constructive dismissal, where you are then allowed to resign without notice. Commissioner.
Thank you very much, Mr. Mawire. Thank you, Chief Justice.
Thank you.
Thank you, Honorable Chief Justice, and good morning, Mr. Mawire. One question from me. It is two parts. The first part is, how would you construe the phrase redress any dispute in Section 63(3)(a) of the Labour Act? Then the second part, does that phrase permit a designated agent to entertain appeals on the merits of a determination, or only to initiate conciliation?
Thank you very much, Commissioner, for that question. This is a very contemporary issue in labor jurisprudence, where the powers of the designated agent have been put under spotlight for some time now. And those powers were eloquently addressed by the Constitutional Court of Zimbabwe in the case of ISO Quant Orozimoko versus Memory Darikwa, where it was explained in detail that a designated agent who is seized with a matter in terms of Section 63(3)(a) has two options, either to redress or to attempt to redress. And when a designated agent is redressing a dispute, he is exercising adjudicative powers where he has to make a decision. Unlike where he is attempting to redress, he is conciliating. And when he is conciliating, he has the same powers as the labor officer who is conciliating. They do not have powers to make a decision. They go to Section 93. This has also been explained recently in the case of Gutura District Council versus Mugayo, where it was explained that redress means the designated agent is making a decision, unlike where they are attempting to redress, where the powers then become those of the labor officer with the necessary changes in Section 93(5). On the second question, again, Gutura District Council versus Mugayo and the ISO Quant case, they are precedents guiding arbitrators, guiding designated agents, but primarily to your second part of your question, it has been a moot question until this case is decided that the designated agent cannot exercise conciliatory powers over a decision that has been made in terms of codes of conduct. The position has, though, been clouded by the legislature, I must say, when they amended Section 101 to say that a labor officer can now entertain a matter that has been completed in terms of disciplinary proceedings and again conciliates, the legislature was trying to address the gap that had been identified particularly by the Supreme Court, where they said in terms of Statutory Instrument 15 of 2006, a labor officer to whom a matter is referred cannot start afresh. He can only handle by way of an appeal or a review. So they just took the ordinary grammatical meaning of the sense that a labor officer could not do that. And then they elevated that very problem that had been addressed by the court to the Labor Act through Section 101. So today we have a situation where labor officers can entertain appeals in terms of 101 from codes of conduct, but then they exercise Section 93 powers, which are conciliatory powers. So maybe it shall take the Supreme Court again or the Constitutional Court to say the very problem that was addressed in Montana meets versus the, I can't remember, the labor officer who handled the matter, where it was ruled that that was an improper way of dispute resolution. But now it's fully entrenched in Section 101. So yes, back to your question, Honorable Commissioner, a DA is not supposed to hear afresh by way of conciliation a matter that has been completed in terms of a code of conduct. Thank you.
Thank you, Honorable Chief Justice.
Thank you, Honorable CJ. Good morning, Mr. Mawire. I also have one question for you. What mechanisms exist under Zimbabwean law to enforce the right to equal remuneration for similar work provided for under Section 65 of the Constitution of Zimbabwe, 2013?
Thank you very much, Judge President. I think the right to equal remuneration is covered squarely under the Constitution of Zimbabwe. Section 65, subsection 7, provides that women and men shall have the right to equal remuneration for similar work. And this is also, this was further given life in Section 5, subsection 2 of the Labor Act, which provides for that right in almost this similar terminology. And just to link the protection of those rights to equality to the Constitution, in terms of the principle of subsidiarity, any employee who is seeking to enforce her rights or his rights may then utilize the provisions of the Labor Act because it's already provided for. So if there is an unfair labor practice around discrimination with respect to remuneration, then the employee will utilize the dispute of right mechanisms in the Labor Act. And it is only perhaps where a constitutional matter arises around that and the Labor Act is sought to be impugned for some reason that the employee may then approach the Constitutional Court directly, or it may be a matter that arises before the Labor Court and then Section 175, subsection 4 kicks in. And also to borrow from Section 56, I think, of the Labor Act, which provides for equality and non-discrimination. Thank you very much, JP.
Thank you, Mr. Mawire. Thank you, Honorable CJ.
Thank you very much, Chief Justice. Good morning, Mr. Mawire. I was going through your nomination form for judicial appointment, And at page 3, you indicate as follows: I am a mature adult, aged 59, in parentheses, fit and proper. Is that intended to make me read anything beyond that simple statement, fit and proper?
No,
Or
Commissioner.
it was just an attempt at being humorous?
No, Commissioner, there's nothing else.
All right.
Okay.
In fact, I must commend that for a 59-year-old, you look fairly young, actually, matter of fact. I was actually surprised. Anyway, let me go to the question that I would want to pose to you. Under the Labor Act, what is a collective bargaining agreement? That's the first part of the question. Secondly, what are the prerequisites for its validity?
Sorry, Commissioner, I didn't get the last words.
It's a
final
two-part
words.
question.
The final words to the second question.
What are the prerequisites for its validity? Okay.
Thank you very much, Commissioner. The Labor Act defines a collective bargaining agreement as an agreement that is negotiated in terms of the Act. So it must be a product of negotiations within the collective bargaining legal framework that is provided for in the Act. Then in terms of the prerequisites for the validity of a collective bargaining agreement, once it is negotiated and packaged by the negotiators, it must be sent to the Ministry of Labor, which is the regulating authority. There is a registrar of labor relations there whose role it is to interrogate these labor market instruments before they become operational. And the minister is also involved in the process. The minister has to be convinced that the instrument is not breaching any the provisions of the Labor Act or any other enactment, or that there are no public policy concerns around the content of the collective bargaining agreement. And once the authorities are satisfied, the agreement will then be registered. And registration is approval by the ministry, it's authentication, but it does not mean that the collective bargaining agreement becomes operational automatically. There is a further step of publication in the government gazette, where it then assumes the status of a law of general application. So it is only upon publication in the government gazette that it becomes valid. But the effective date may not necessarily be the publication date. You may include in the CBA an effective date of the CBA, which can be in retrospect. But first of all, it has to be published in the government gazette, and that marks the final rung of the validity process, Commissioner.
Thank you very much. But there would seem to be a total absence of the principle of buying in on the part of persons that are going to be directly impacted by a collective bargaining agreement. Is there no space, no role for members or even their branch representatives to become part and parcel of the process of rendering the agreement itself valid?
Thank you very much, Commissioner. The Labour Act is its safeguards with respect to participation of ordinary members. Because of the collective regulation of labor relations in this country, not every individual employee and not every individual employer may then be involved in the final packaging. But at the commencement of negotiations, the representatives have to make sure that they have a mandate. And in terms of Section 77 of the Labour Act, they should actually provide for that mandate where it's certified by the membership. And once that mandate is then recorded, then it means whatever comes out of those negotiations, it's assumed that the representatives will be consulting with their membership. But when it comes to the actual negotiation itself, there's been a practice where some have wanted to disown these collective bargaining agreements. And in 2023, through amendment number 11, the legislature amended Section 82 to indicate that those who have an interest must participate through the recognized structures of the NEC. And if you do not participate, it shall not be a reason for you to want to distance yourself from the collective bargaining agreement. This had happened with cases like Econet, cases like TEL 1, which the Supreme Court also handled, where the issue of freedom of association was used by some of the players to distance themselves from the products of NECs. So the legislature has since plugged that gap. But with respect to individual members, I think the question of giving a mandate in terms of Section 77 covers that concern, Commissioner.
What would Section 78 then be speaking to, if not ratification in total by members or branches of the members concerned? Because 78 seems to suggest that ratification is a key component of the total package that constitute the basis upon validity is rendered to a collective bargaining agreement. Correct?
Yes, Commissioner, I might be mixing my practice with the actual provision here in Section 78. My recollection would be that ratification is not always a compulsory process, but where ratification is required in terms of your own internal processes, then you must follow that ratification. If your constitution, trade union constitution says all collective bargaining agreements, maybe by a branch, must be ratified by another authority or membership, then yes, you have to follow that. But if there is no specific mandatory provision for ratification, the structures that you would have come up with are the structures that should follow due process for the collective bargaining agreement to be owned by everyone, unlike a works council agreement, which has to be ratified by 50% plus of the membership and the trade union for it to be effective, Commissioner.
Thank you very much, Chief Justice.
Thank you. Yes. Thank you, Chief Justice. Good morning, Mr. Mawire. I have one question for you. How does Section 90, capital letter A of the Labour Code relax strict rules of evidence and procedure? And what limits remain to prevent injustice through procedural laxity?
Thank you very much, Commissioner. This has been a very topical issue discussed by stakeholders in the labor administration field. The extent to which the labor court must be flexible to accommodate the players that appear before it, including self-actors. It has been very topical. And Section 98A talks to procedure and evidence in the labor court as a heading. But in terms of the substantive provisions, they address more evidence issues than the general procedure. I think it is the rules that talk more on the procedure to be adopted by the labor court generally. Your rule 12, I think, and rule 26. They then say the judge is at liberty to follow any procedure that they deem fit, and as long as it is going to enable the judge to come up with fair and just decisions. But back to 90A, on evidence, it then says the labor court is not bound by strict rules of evidence. And the rules then qualify that to say admissibility of evidence. So when this matter came up in courts, I think it's Triangle versus Gauke, if I'm not mistaken, it was discussed that this is not a clean slate for the labor court to depart from what is provided for in enactment. In that case, the labor court had handled an appeal, but at the tail end, I think it was towards disposition, the labor court then employed review principles and came up with a decision as if they had handled a review, and the Supreme Court said that was a very wrong approach to take. So in as much as flexibility is introduced by Section 90A with respect to adduction of evidence, there are still strict rules with respect to cross-examination of those persons who appear before the court. There are rights that are given to litigants themselves and to the court to still narrow down any flexibility challenges that might erode the structure of what constitutes a court. Yes, the labor court is supposed to dispense justice and equity, so the courts have said, but this must not be at the expense of established principles of running a court, as it were. So the safeguards that are there are that the judge must always ask themselves whether they are not departing from established rules of court when they accommodate the flexibility around the adduction of evidence. Thank you, Commissioner.
Thank you. I'm answered. Thank you, Honorable Chief Justice.
Thank you, Chief Justice. Good morning, Mr. Mawire. I want to go back to the line of questioning that was started by the Attorney General and that the Chief Justice followed up on. Justice must not only be done, but seen to be done. So a judge must be clearly independent and impartial. You are associated with 9 different national employment councils as chairman, 5 in the past, 4 currently. And when you chair a national employment council, you are looking after the interests of the employers' associations and the trade unions in that NEC. And some of these I see on this list are fairly litigious. We see them in the courts, we see them in the law reports. You've also been legal advisor to the ZCTU and to MCOS. Now, let me pick, by way of example, Communications and Allied Services Industry of Zimbabwe. You currently chair the NEC. If you are appointed as a judge and a matter comes before you involving perhaps the trade union or the Employers Association or the NEC itself. How does the answer you gave help you in that situation? How does reasonableness and whatever you were saying come in? Would you not be required simply to recuse yourself because of that mere association? How would that affect you?
Thank you very much, Commissioner, for that question. It's a question that I considered very deeply and comprehensively before I decided to participate in these attempts to join the bench. And I noticed that I've been able to maintain my impartiality even as I am the chairperson of these employment councils, because I have arbitrated in cases where I've been a chairperson of the employment council before.
Let me just stop you. You become a judge of the labor court.
Yes.
A matter comes before you involving one of these people that you currently are presiding over as chairman. Do you not have a duty to recuse yourself and not deal with that matter purely because of that association?
Okay, thank you very much, Commissioner, for that clarification. In fact, I can only recuse myself if the matter perhaps commenced when I was still chairing the NEC, and I took an active part in its resolution. I'll give an example of the NEC that you have just referred to, the communications and allied one. If a matter then was brought up with respect to the non-participation of some employers in the NEC and the dispute around freedom of association, I would recuse myself because I was heavily involved in the Econet case and in the Net 1 and Tel 1 cases where they were members of the NEC, but
Let's just try and focus on the question.
Yes, I would recuse myself, Commissioner, if there was any linkage of my chairpersonship of a particular employment council with a matter that is before me. Because the fact that I was a chairperson of the employment council on its own does not necessarily mean that I have an interest or I have a consideration that might cloud my judgment. Who knows, there might be a question of someone saying I'm entitled to maternity leave.
Let me just ask you to focus on the question. Okay. Can you switch off your mic? I'm talking about appearance. Yes. The appearance of impartiality in a judge. You are currently the chairperson of this NEC. The president decides to appoint you as a judge. In July of this year, a matter comes before you in which you were not involved, but in which this NEC is a party. And the other party objects and says, I do not want you to preside over this matter because just 2 months ago you were chair of this NEC. I do not believe you would be impartial. Would you not be required to recuse yourself?
Appreciated, Commissioner. I think this is the beauty of law, because these are the very circumstances which cause a judge to exercise his or her minds. Otherwise, there wouldn't have been any reason for such a law which says
Mr. Mawire,
recusal.
Just answer, don't
okay,
put in the trappings.
Thank you, Commissioner. I will exercise my mind to the request based on the established principles of recusal, particularly the fact that justice must not only be done, but must be seen to be done, but also guided by the fact that I will take an oath before the President or the Chief Justice to uphold the law impartially, and I will then have to be guided by law when addressing the request. And if it is frivolous, dismiss it. If I'm convinced that, yes, the request is genuine and it's supported, I would then have to recuse myself.
I actually want a yes or no. The party says you've chaired this thing 2 months ago. I don't want you to preside over the matter. For that reason alone, would you recuse yourself, yes or no?
No, I will not.
Thank you, Chief Justice.
Thank you, Chief Justice. Good morning. Yes, I have one question for you. Does the Labour Court have unlimited jurisdiction over all labour matters?
Thank you very much, Commissioner, for your question. Yes, the Labour Court is limited, is exclusive jurisdiction in labour matters, except for those that are excluded in terms of law and in principle legislation. For instance, the application section of the Labour Act says it shall apply to all employers and employees except those whose conditions of employment are provided for in the Constitution of Zimbabwe. So you will go to, for instance, your commissions and also the Public Service Act. Employees are governed by the Public Service Act. Your defense or your disciplined forces are also excluded. That is your military, your air force, your police service, your prison services, employees working in the president's office on security duties, or any defense forces of a foreign state who are working in Zimbabwe. That would be one good example of an exclusion in terms of the scope of the Labour Act. Then we have also noticed the definition of dispute of interest and dispute of right. But most importantly, dispute is also defined in the Labour Act to mean a dispute relating to any matter relating to employment, which is governed by the Labour Act. And further, Section 89 of the Act, which talks of functions of the Labour Court, provides for the scope of functions of the Labour Court with respect to applications, appeals, review applications, as would be exercised, powers of which would be exercised by the High Court as well, and a whole list of other sources of the jurisdiction of the Labour Court, including references from the Minister and jurisdiction from other pieces of legislation, like the Public Service Act says, yes, the Labour Court shall not have jurisdiction on any labour matter except where there is an appeal from a decision made on misconduct charges. Then the Public Service Act says the Labour Court has jurisdiction. So if we say it has exclusive jurisdiction, we must qualify that. And there's also one contentious area where we talk of, for instance, applications for declaratory orders or interdicts, where there's been some discussion, and the Supreme Court has since clarified that as long as it is a purely labour matter, then such applications can be handled by the Labour Court, because in terms of Section 89, subsection 6, no court other than the Labour Court shall have original jurisdiction in the first instance in a purely labour matter. Thank you, Commissioner.
It's okay. Thank you very much. Thank you, Chief Justice.
Yes, we have come to the end of your interview. You are excused. Thank you. Thank you. Yes, we'll take a 10-minute break.